September, or October. He says he sent a letter to me, and the letter was addressed to 1225 Johnson Ferry Road. My address is 137 Johnson Ferry Road, and the 1225 address, I have a forwarding, but it's also a law firm that I'm still affiliated with, and it's right down the road. They would bring me anything. So I haven't had any email communication whatsoever, and I haven't had one phone call. He's not saying that I haven't followed up with him. He's saying, oh, I sent a letter by U.S. Postal Service following up on discovery, but he didn't send an email. He didn't make a phone call, and he didn't do that for 3 months. And so what we're ready to do, Your Honor, is we're ready to go in accordance with your court order with a bench trial. And your court order is clear. If you don't submit a pretrial order by the deadline, October the 6th, you've waived it. And the law is clear, Your Honor. He says he followed up regarding discovery. Your Honor, the law is clear on that. If you don't have a good faith conference, if you don't diligently follow up with your discovery, then you waive that. You must diligently, in order to use the compulsory system, you must diligently follow. But 3 months without an email, 3 months without a phone call, Your Honor, and he says he sent a letter. I'm sorry, that's just not credible. So
may I?
Yes, go ahead.
This is Mr. Katz and his client's case. He's the plaintiff. He filed a complaint with an address at the end in his signature block with an address of, and I'm pulling up the complaint now. Everything's moving slowly because I'm on the Zoom. But the address on the complaint is the same address that I sent discovery to. He's now saying that that's no longer his address, but he has not filed into the case a change of address, which he's required to do. Speaking of requirements, the address on the complaint is the Katz Law Firm, 1225 Johnson Ferry Road, Building 100, Suite 125, Marietta, Georgia, 30068. This is the address that I've sent discovery, that I've sent all correspondence to. Now, if he's not getting that, that's his fault, not mine, because this is the address that he indicated to the court and to all parties associated with this case where he could receive communication. And that's where I sent it. And now he's saying he's at a different address and that they forward the mail from that old address to his new address. Then
did you keep a copy of the letter?
no, ma'am, I did not receive any letter from him. And I will tell you, Your Honor, it's
Wait,
just not credible.
hold on 1 second. I'm asking Mr. Douglas, does he have a duplicate of the letter?
I'm sure I do somewhere. Yeah.
Okay. And you never received anything, Mr. Katz.
No, I did not. And not just cricket, Your Honor, not a phone call, not an email, but he communicated on August 5th by email. I responded in 2 hours, within 2 hours, and I followed up with him on August the 7th. Nothing, not a phone call, not an email, nothing. I even followed up with the ADR and said, hey, have they contacted you? They said no.
Okay.
And so,
Mr. Douglas, what did your letter say, Mr. Douglas?
Because he didn't actually communicate with me. He communicated with a paralegal in my office about ADR and about mediation. And so when he's saying that he communicated with me, he didn't communicate with me.
that's precisely who I received.
I was in the middle. Stephen, please. I'm mid-sentence. You've done it throughout this Zoom call. Please stop. As a courtesy, please, as a professional courtesy, please allow me to finish a statement. I have been in back-to-back jury trials. During the time that my office was communicating with him about mediation, I was in a 3-week jury trial down in Muskogee County. So I have not had any communication with Stephen, to be honest. When he says he didn't email me in August, September, October, I've never emailed Stephen to my knowledge. My office has been communicating with him about mediation. And to be honest, I can't speak to where the ball was dropped in terms of getting that scheduled. As he admitted, my office initiated the communication about mediation. He's just admitted that. I also, again, trying to get to the bottom of why he wouldn't have gotten my letter and my discovery, I asked him, is this your address? And he says, no, our address changed. So again, that's his obligation to communicate. He's attempting to make it appear that I'm misrepresenting facts to the court. But again, I have what's clear is that there's a certificate of service filed into the case that says that I did in fact send him timely discovery, and it says the address where I sent it, which is the address on his pleadings.
But what did the letter say that you sent? So you sent discovery, but what's in the letter?
It's just a basic 6.4 letter that, hey, we not gotten discovery responses within 30 days. When can I expect to get discovery responses?
Okay.
That's it.
No, Your Honor, there's no letter received. And I will tell you something. If he chooses to have a paralegal contact me, which he did on August 5th, that's the only communication I've ever received saying, give me dates for mediation. 2 hours later, I respond to the person, Mr. Castillo, and say, these are the dates I'm available. This is my trial schedule. This is my trial schedule throughout September. I don't receive a response. 48 hours later, on the 7th of August, I sent another email to Mr. Castillo because that's the person who sent me the communication, okay, and who's handling it for their office. But the problem with this is I don't think there was any letter ever sent to me because he can't produce it to you today. He should have it ready in hand, this 6.4 letter. Number two, it's a law firm that I'm still associated with. But what really speaks loudly is that a lawyer doesn't get on the phone and has admitted August, September, October, when you have a court order that says mediate by September 26th, file your pretrial order by October 6th, or I'm going to try this case as a bench trial. Well, when we looked at it close to October the 6th, I said, I called my client. I said, are you happy with the bench trial? He said, absolutely. I want to get this ordeal over with. But all this idea, if he sent a 6.4 letter, why didn't he file a motion to compel? 5 months later, nothing. I tell you, that's not credible, Your Honor. If he sent me a letter, he'd have it. If I didn't respond like he says, then he would have filed a motion to compel, or he would have gotten on the phone. And there's many judges in your court, Judge Eaton, for example, says, hey, sending a 6.4 everything, you got to get on the phone, you got to talk to the other side, and you got to resolve these kinds of things. All right. He didn't do any of this, and he admits it. He doesn't say, hey, I'm not responsive. He just says, hey, I sent you a letter. Well, that's just not good enough, Your Honor. And saying that and admitting that there's no communication whatsoever by email or by telephone from him to me speaks volumes here. And so we can do whatever we want with this case. You can order whatever you want, Your Honor. But those are the facts.
May I
Okay.
respond, Judge?
Yes, but briefly, because I've got other people waiting.
Briefly.
Okay.
Mr. Katz ironically speaks to not picking up the phone. I've not gotten a single call from Mr. Katz, and it's his case in terms of the consolidated pretrial order, in terms of mediation, in terms of any of the obligations pretrial. I've not gotten a single. He's not picked up the phone. So it's so ironic that he's accusing me of doing something that he himself hasn't done. Second of all, whether I sent the 6.4 letter the 6.4 letter is a prerequisite to filing a motion to compel. You're absolutely right. I haven't filed it. That doesn't alleviate you of your obligation to respond to discovery. You're not saying that you didn't get the discovery. You're just saying you didn't get the 6.4 letter. Okay, fine. Even if that's true, your client is still obligated to produce responses to the discovery that we sent, and you haven't done that.
And sir, you have a duty to diligently follow up. And if you had filed a motion to compel, I can guarantee you, or if you had picked up the phone, or if you
So
had
you're saying you
emailed-
would have responded if I filed the motion to compel?
No, if you had picked up the phone, if you had
Is
sent
that
an email
an attorney's
communication.
obligation?
You did none of it.
Okay.
You did
only
none
to
of it.
respond to
Time out.
discovery when you're compelled?
Time out. All right. What I would love to see, we need to get this set for trial, but what I would love to see before the end of the year is a judicially hosted settlement conference. I'd like to send you guys to that. Is that feasible?
It is for me, Your Honor. I've checked with my client, assuming that you would order something, either a trial or a settlement conference. He's available. I In early December, I've got some large hearings before Judge Dunaway.
Okay.
And I've got a jury trial and especially set on December the 3rd in Gwinnett. But say from December 12th on, I'm good.
Okay. And how about you, Mr. Douglas? Is it feasible to do it before the end of the year?
I believe we may have filed something to this effect in another case before, Your Honor. But my situation is there are 3 lawyers recently that have left our firm. And just to full disclosure, one of them was having an inappropriate relationship with a lawyer, opposing lawyer in an active case. And so I contacted the bar and they told me I had to fire her immediately. Another was in a car accident and sustained a major head injury and is no longer practicing law. So those 2 were completely unexpected and came out of nowhere. And I had to assume all of their cases. The third one is the attorney that was running our criminal defense practice. She had a baby girl and we gave her 6 weeks maternity leave. Right, the week before she was scheduled to come back, she asked for an additional 6 weeks. And because of the prior 2 situations that I just explained, I could not give that to her. And so she's now with the DeKalb DA's office. She left our firm.
Oh,
so,
okay.
So I say all of that to say that I am now, until we are able to find, and I'm actively and aggressively trying, but we have not yet found candidates to take the place of these 3 lawyers. I have the caseload of 4 lawyers, including criminal cases and I'm not even a criminal defense lawyer. So I have conflicts on top of conflicts on top of conflicts for months.
Your Honor, I would suggest I asked my client if we could move it over into January, anticipating that maybe the court schedule, and he said he was willing to do that. And so to handle these kinds of things, I very much understand what opposing counsel goes through, and those kinds of things have become all too common lately. So if you want to put this over into January, then we'll stipulate to that. We have no issue.
Okay. So let's say by the end of January, a judicially hosted settlement conference. Okay. And good luck, Mr. Douglas. That sounds terrible. It sounds like you're under it right now.
Yeah. Thank you. I appreciate it.
Okay. Okay.
So will we get an order from Your Honor to that effect, or
yes,
are you ordering us now on the call?
I mean, I am ordering that, but we can also put it in writing. It sounds like the best we can help you right now is just make sure you have a lot of paper and reminders.
Yeah. Thank you.
Yeah. Okay. All right. Thanks. Thanks, Mr. Katz, too. Thanks, Mr. Douglas.
Thank you.
Have a good one.
Take care. Bye-bye.